Okay, the United States Court of Appeals for the Fifth Circuit is now open according to law. God save the United States and this honorable court.
Good morning. The first case on our docket this morning is 20-10447, United States versus Aldridge. Mr. Curtis.
Thank you, Your Honor. Good morning. My name is Chris Curtis, and I represent the appellant, Mr. Aldridge, in this case. Simply stated, the district court imposed an illegal sentence when he imposed 5 separate 14-month sentences to run consecutively for a total of 70 months based upon the revocation of 1 term of supervised release. In January of 2020, the court revoked 5 terms of supervised release, sentenced Mr. Aldridge to 3 weeks custody of BOP, and reimposed, and I quote, an additional term of supervised release of 24 months. The record of the January 13th, 2020 revocation hearing unambiguously establishes that the district court imposed 1 additional term of 24 months. And also the written judgment, which combined all the cause numbers, established this exact same sentence. It established that the court imposed a term of 24 months. Therefore, when the judge subsequently revoked that single 24-month term of supervised release the following May, the statutory maximum sentence he could impose at that time was 24 months. And of course, he actually imposed a total sentence. He imposed 5 sentences of 14 months for a total of a 70-month sentence. Under the control.
Mr. Curtis,
Yes.
Curtis, the court violated revoked conditions in all 5 of the cases, and then he imposed an additional term of 24 months. So why isn't there at least an ambiguity of whether he imposed that in all 5 cases that he revoked?
I don't believe so, Your Honor. In fact, I'd urge that there was no ambiguity in the case there between the oral sentence and the written judgment. The oral pronouncement and the written judgment actually have the exact same language, which was that he was imposing a term of supervised release of 24 months. Therefore, we don't have an ambiguity.
But the written judgment shows that he imposed the 24-month sentence in each of the 5 cases.
I disagree, Your Honor. The written judgment was actually one judgment. All 5 cause numbers are consolidated in the style of the case. But again, the judgment doesn't mention 5 terms of supervised release. And to even take that a step further, the government's argument supports my position on that even further, in light of the fact that the judgment doesn't even mention whether any of these sentences, if there were in fact 5 terms of supervised release, there's no mention whatsoever that they would run concurrently or consecutively from that January 2020 hearing, which is completely inconsistent with how it was handled all the way through this case, including the judgment that we have now from May of 2020, where there were 14 separate sentences of imprisonment, and the judge specifically says they're consecutive. So I don't think there's an ambiguity at all. The language is clear and unambiguous that he imposed a term of supervised release. And I think the case law is also clear that when a judge does that, he's only imposed 1 term of supervised release.
Which case did he impose it in?
That's not clear. He didn't specify which case the single term applied to, but the fact is it still was just 1 single term, Your Honor. And I don't think there's any ambiguity in that regard. So I don't think that we get to do what the government suggests and start poring over the record and trying to parse out what the court's intent is. I think since there's no ambiguity, then you simply go to the oral pronouncement, and that's what we're stuck with. There was 1 term of supervised release, and therefore in May, when we get back around to a second revocation, the the judge was limited to a 24-month sentence. The government has also argued that the error was not clear, and I disagree with that. I think I've addressed that pretty clearly in the reply brief, but the law on this circuit is clear and well settled. Number one, first of all, you go with the oral judgment. Second of all, that if a sentence exceeds a statutory maximum, which is exactly what we would have here, is that is error that's clear and obvious, such that it satisfies the first prong of plain error and the second prong of plain error. And it also, the prejudice is clear from the situation where the defendant received a total sentence of 70 months as opposed to a statutory maximum of 24. And I think the Vera case that I cited, as well as the Rojas case, are exactly on point as far as controlling precedent, that this is clear and obvious error. It satisfies all four prongs of the plain error standard, but also the Dillon case that I cited out of the Third Circuit is exactly the same situation they were presented with. And of course, they found that that was plain error, and it was plain and obvious because the language in the statute itself talks about a term of supervised release versus multiple.
We didn't have 5 separate cases, though, in that case, did we?
That's correct, Your Honor. That's true. The other case that's extremely close to this case, though, is Eskridge. And again, we're only talking about 2 cases there, but we did have 2 separate cases in Eskridge. And in the Court of Appeals out of the Seventh Circuit, it found that this was a plain error. And they did exactly what has happened in this court as far as on appeal. They got the transcript of the oral pronouncement, and they resolved it. They resolved it with the language that was in the oral pronouncement, which is virtually the same as the language we have in this oral pronouncement. I know that's not binding on this court, but it's certainly instructive, and I think it strongly supports the position that I'm taking on this appeal. Your Honor, I think the government's brief in this case actually supports my argument even more strongly. The government is asking this court to go back and parse together bits and pieces of the record to determine the judge's intent. And again, the case law is clear under Martinez and Shaw, United States versus Shaw 920 Fed 2nd 1225, which is a case cited in Martinez, which is in my brief, that you only get to do that if there's an ambiguity. And I strongly suggest that there is no ambiguity. The language that I'm relying on is exactly the same in the oral pronouncement as it is in the written judgment. And you don't get to go back and say, okay, well, let's figure out what the judge intended. But even if you did, I would suggest that the facts that the government's relying on, and that is that there's no discussion about whether the sentences, if more than one sentence was imposed, there's no discussion about whether they would run concurrently or consecutively. That in itself weighs heavily in favor of my argument that the intent by the district court judge was to impose a term of supervised release, just like he did. But again, I urge that we're not there, because there's not an ambiguity between the language. I also urge that there's one judgment entered in this case. And again, the government in its brief, it talks about this case. And my suggestion is that again, that just weighs in favor of what I'm arguing is by the time we got to May of 2020, we had one case, one term of supervised release. And it's plain error to have sentenced above the statutory maximum for just one term of supervised release. Again, there's no question under the controlling law in this circuit, that if the court imposes a term that exceeds the statutory maximum, that is plain error. That is a clear and obvious error, and it's error that obviously has to be, the court should exercise its discretion. I would point out that the Bain case which is cited by both parties in this case, was a previous case before this court involving similar question about what happens when a term of supervised release is imposed. That was disposed on that was a plain error case, much like this one, but it was disposed of under the prejudice prong, which we can't get there on this case with Mr. Aldridge. He was clearly prejudiced. If we're correct on our appeal and our issue here, he received a 70-month sentence, which exceeded the statutory maximum. And under Vera and Ojas, cited by me in the both my briefs, that's prejudice. That's substantial prejudice, and it also warrants the court exercising its discretion to reverse the sentence. So I think that unless there's other questions from the court, I think that I've covered the argument in this case. I also think that I I think I've covered the issues that have been raised in the government's brief, and I think that the government just simply can't get past the argument that oral pronouncement controls, and there's no question beyond that unless they can show an ambiguity, and they can't. Thank you.
Thank you, counsel. You've saved time for rebuttal.
All right.
Mr.
Thank you.
Gilstrap.
Thank you, Chief Judge Owen, and may it please the court. Stephen Gilstrap on behalf of the United States. The main issue that Aldridge raises in this consolidated appeal fails for two central reasons under the demanding plain error standard. First, a review of the record in the 5 cases below, which have been consolidated for the purposes of this appeal, suggests that the district court imposed 5 concurrent terms of supervised release in January 2020, just like had been done in the original judgment from the Middle District of Florida. At most, the record is unclear on this point as to whether the district court continued to impose 5 concurrent terms of supervised release or converted 5 concurrent terms of supervised release in 5 different cases into a single term, in which case I think, as Judge Davis pointed out, it would be unclear which case that term of supervised release was in. And as this court most recently noted in the Smith-Garcia case, which Mr. Curtis, I don't believe, mentioned in his argument, an unclear record should not be a basis for plain error. Second, and I think this is a really important point, even if this court determines that the district court imposed a single term of supervised release in January of 2020 and did, as Mr. Curtis suggests, convert concurrent terms from 5 separate cases into a single term, Aldridge still cannot show plain error here. And that's because the last thing that this court has said on this topic was in the Smith-Garcia case from last February. And in that case, the court recognized under the plain error standard in a very similar factual scenario that this court had yet to decide whether following multiple convictions in terms of supervised release, an intervening single term could thereafter be followed by multiple terms of supervised release and sentences upon a subsequent revocation. That's U.S. versus Smith-Garcia, 802 Federal Appendix 822. Like I said, the court specifically said that it had not decided the very issue under plain error that Mr. Curtis is suggesting is now clear and obvious. And given this lack of clarity, both factually and legally, Aldridge cannot show that the district court plainly erred. And finally, I don't believe Mr. Aldridge addressed it, or sorry, Mr. Curtis addressed it in his opening argument, but the substantive reasonableness argument, which is the second issue raised in this appeal, really rises and falls with the first issue, and that argument that Mr. Aldridge has made falls in tandem. First, I'd like to delve into the background just a little more to clear up any ambiguity in the record here. There were 5 separate prosecutions for bank robbery and attempted bank robbery in 5 different jurisdictions related to Mr. Aldridge. He was arrested in the Middle District of Florida, and under Rule 20, the other 4 prosecutions were transferred to that district so that he could plead guilty and be sentenced. He was sentenced to 87 months imprisonment to run concurrently, and then a 3-year supervised release term, again, to run concurrently in each of the cases. When in December 2019, probation filed a violation report on Mr. Aldridge, it filed that violation report in each of the 5 cases. And when the court held a hearing in January of 2020 on this revocation issue, it had a transcript that was filed in each of the 5 cases. And as Judge Davis pointed out, a copy of the judgment was filed in each of the 5 cases. Now, Mr. Curtis focused on the fact that the written judgment lists all 5 cases on the front page, and that is correct. But I think what's interesting, and if you can contrast this with what the court did when it revoked the second time in May, is on the 2nd, 3rd, and 4th pages of the judgment where the sentence is actually imposed, there's only one case listed there. It's the 289 case number. The judgment does not continue to list all 5 cases. And I think what's going on there is the district court intended to list the 289 case number for one judgment, the 290 case number for another judgment, the 291 for another judgment, and there's just a clerical error in the written judgment. It does list all 5 cases on the first page, but I think it's very interesting that the January 2020 revocation judgment only lists a single case number on that 2nd page. And when you look at the transcript, it is true that the district court imposed, quote, a term of supervised release of 24 months. But the issue is it had called all 5 cases. It noted at the outset of the transcript that there was a series of cases. And then when it went over the potential punishment, it noted that the punishment was, up to 2 years in this case. And so I think there's some ambiguity that Mr. Curtis wants to ignore that's caused by the fact that, as Judge Davis pointed out, there are 5 underlying cases here. This is not a case where there's a single case with multiple counts of conviction where the supervised release terms are imposed on those multiple counts within a single case. There are 5 separate cases here. And I truly and honestly believe that if Judge O'Connor had intended to take concurrent terms of supervised release from 5 separate cases and convert those into a single term in, I presume, one of those cases, he would have been a lot more explicit about what he was doing. And given that ambiguity, I think this court can look at other parts of the record which show what the court's intention was and what was understood below. In the second supervised release violation report that probation filed in March after Mr. Aldridge violated again, it filed that report in all of the 5 cases below, not one case, whichever case supposedly had the term of supervised release. And in that violation report, it cited this court's decision in United States versus Gonzalez, which makes clear that a court can take concurrent terms of supervised release and impose consecutive sentences. There would have been no reason for probation to flag that issue had it understood that the district court had taken concurrent terms of supervised release in 5 separate cases and transformed them into one. And then when we get to the May 2020 second revocation transcript, the district court makes abundantly clear that the potential punishment is per case. And when he clarifies that, Mr. Aldridge doesn't object. He says he understood and things proceed as usual. And he pleads true to the violations and goes on from there. So no one was surprised at the May 2020 judgment, the May 2020 revocation hearing when Judge O'Connor clarified that no, there in his mind were still 5 terms of supervised release that he could use to impose consecutive sentences. But I don't
have the judgment. I don't have the judgment after the January hearing. Now, he did list only one case when you turn the page. Tell me about that.
Sure, Your Honor. On the front page, Mr. Curtis is correct that all 5 case numbers are listed, I think because it was a consolidated revocation hearing. But on the 2nd, 3rd, 4th, however many pages are left in the judgment before he attached the Middle District of Florida judgment, there's only one case number listed. It's the 289 case number. And it's the government's position that what the intention was there was to list each of the 5 cases because, as Your Honor pointed out, that judgment was filed in each of the 5 cases, but only that 289 case number is listed. And I think the court can contrast that with the second revocation judgment in May 2020 after the court revoked a second time, which lists all 5 case numbers throughout the judgment. And so I think that that's at least a point of ambiguity as to what's going on in the written judgment. And given that there are 5 cases here, I don't think you can put the same amount of weight on the fact that the court used the word term in the sentence in the revocation hearing from January, because there were 5 cases being called. There was a series of cases. And so that distinguishes this case from all of the out-of-circuit authority that Mr. Curtis relies on. And I want to clear up a few points before I get into this court's case law on this issue from the out-of-circuit authority. First, Dillon is not the exact same situation, nor is the 11th Circuit's decision in Starnes. Those cases involved a situation where the original judgment imposed a single term of supervised release. They did not involve the same situation where there was an original judgment that clearly imposed concurrent terms of supervised release, and then there's a question of whether the district court converted that at a first revocation into a single term. So those cases are very different in that respect because there never were concurrent terms of supervised release in those 2 cases. Eskridge from the 7th Circuit is more similar because it involves this issue of there were multiple concurrent terms in a judgment and then it was revoked and so on. But Eskridge is different because Eskridge did not involve 5 different cases like this case does. It involved a single case where there were multiple counts within a single case, within a single judgment, where concurrent terms of supervised release were imposed. So those out-of-circuit authorities don't get Mr. Aldridge as far as he needs to go for plain error. And getting to this court's authority, and I think, as I said at the outset, even if this court were convinced that the district court did convert these concurrent terms of supervised release from 5 separate cases into a single term, Mr. Aldridge still can't show plain error. And that's because the last thing that this court said on this topic was in its Smith-Garcia decision. And it specifically noted that it had not addressed this issue. It cited Eskridge and these other out-of-circuit cases, but it specifically noted that it had not addressed this precise issue. And it cited to this court's U.S. versus Garcia-Gonzalez decision and made clear that an error is not plain if it concerns a matter of first impression or requires an extension of our precedent. Given that Smith-Garcia did not address this issue and made clear that it hadn't addressed this issue and that this court hadn't addressed this issue, we're in a circumstance where to find plain error, this court would have to extend its precedent in order to do so. And because of that, Mr. Aldridge can't meet the second prong of the plain error test. Now, I heard Mr. Curtis say that, well, it is plain error because he would have been sentenced above the statutory maximum if you agree with me that there was only one term and he could only sentence on that one term, even though this court has not specifically addressed that issue. And he cites the Vera case in his reply brief. A couple points on this that I think it's critical to flag. First, the Smith-Garcia case addressed this exact argument where a defendant said, my sentence is above the statutory maximum because the district court could only sentence me on one term as opposed to 2 terms of supervised release. And in that case, the court said, well, we usually review de novo whether a sentence exceeds the statutory maximum, but here there's a threshold issue that we have to decide, which is whether the district court could impose 2 consecutive sentences as opposed to 1. And because of that threshold issue, you don't get to the above the statutory maximum, and you have to go through the 4-prong plain error analysis in order to get there. And that's the problem that Mr. Aldridge runs into is, given that this court has not addressed this issue and made clear that it hadn't done so in Smith-Garcia, and then said in Smith-Garcia that because we haven't addressed it, we can't find plain error, and that's the last thing that was said on this topic from this court, Mr. Aldridge cannot show a clear or obvious error, and he cannot use the claim that it's above the statutory maximum to get around the plain error analysis. And this court's decision in Smith-Garcia makes that abundantly clear because it was the exact same factual scenario, with the one tweak of Smith-Garcia, like all of these other cases, involved a single case, a single judgment, and concurrent terms of supervised release within that single case and within that single judgment. Here, as I've noted repeatedly, there are 5 cases, underlying cases, and the 5 concurrent terms were in those separate cases before the revocation process here.
Let me ask you this. If we don't agree with you that when the district court turned the page and then put the term of release in each judgment, there's just nothing that shows us that's a clerical error. What does that do to your position?
I think that Mr. Aldridge still loses under that factual scenario because this court has not said and made clear in Smith-Garcia that it had not yet said this, that where there are multiple terms of supervised release and there's a revocation where arguably those multiple terms are converted into a single term, this court hasn't decided whether a district court can thereafter impose multiple sentences on a subsequent revocation. Smith-Garcia makes that clear. And because this court hasn't addressed that issue under Smith-Garcia, under Garcia-Gonzalez, it would require an extension of this court's precedent to rule in favor of Mr. Aldridge. And because of that, there's not a clear or obvious error here under this court's precedent. So even if you were to agree with Mr. Aldridge that in January 2020, the record is sufficiently clear that there's just one term of supervised release, this court hasn't yet said that a district court could not go back and impose consecutive sentences upon that, given the original judgment. That issue just hasn't been decided in this circuit, and so there's not clear, obvious error. And as I highlighted, the out-of-circuit cases that Mr. Curtis relies on involve different factual scenarios. None of them involve a situation where there are 5 separate cases involved. And as I said at the outset, I just think when you look at the record, the district court would have been a lot more clear if it was taking concurrent terms from 5 separate cases and converting them into a single term. Just very briefly on substantive reasonableness, as I noted, it really rises and falls with the first issue because each of the 5 consecutive sentences was within the applicable policy statement range. And so the sentence is entitled to the presumption of reasonableness, and Mr. Aldridge can't overcome that presumption. The government has its arguments in response in its brief and would rely on those on the substantive reasonableness point to the extent the court has no further questions. And with that, the government respectfully asks that this court affirm Mr. Aldridge's sentence for these reasons and those outlined in its brief. Thank you, Your Honors.
Thank you, Mr. Curtis. Rebuttal.
Thank you, Your Honor. First of all, with regard to Smith-Garcia, of course, that's an unpublished opinion and it's not binding on this panel. Second of all, I think that Smith-Garcia is the issue that was not clear and obvious was whether or not the multiple terms of supervised release had been revoked. That's not the case in Mr. Aldridge's case. If you look at the docket sheet for each of the individual cause numbers, I believe that they reflect that the supervised release was revoked back in January on each one of those cases. So in any event, and that's in the record with regard to one case, it's on the record at page 545. I would have to go back and go through, as court I'm sure is aware, the record in this case is pretty unwieldy because it wound up being just repetitive of all 5 cases, and it's I think a couple thousand, almost 3,000 pages long. So I would have to go back and find the docket sheet for each individual case, but I believe the revocation was that each of the supervised release terms were revoked. So we're not even talking about a situation like Smith-Garcia. The problem is the government still can't address the fact that the oral imposition of sentence in this case was that he revoked the terms of supervised release and he reimposed a term of supervised release of 24 months. He entered that single term of supervised release on one judgment that had all of the combined cause numbers on it. And then just a copy of that judgment was put in each case. There's no ambiguity. He wants to create the ambiguity by arguing the intent of what he thinks the intent of the judge was, but you can't get there until you show the ambiguity because the written judgment and the oral judgment both say a term of supervised release and all 5 terms were revoked. So, and even if you did take that extra step and say, oh, well, we get to look at the whole record. Well, the record doesn't support what he's saying because the court never issued any kind of language, either in the oral pronouncement or in the written judgment, that number 1, there were multiple terms of supervised release being imposed, and number 2, that they ran concurrently or consecutively or whatever the case may be. That wasn't done, and it's consistent.
In May, he clarified it, didn't he?
I'm sorry, Your Honor.
In May, judge clarified what his intention had been.
In May, I don't think the judge caught it because the probation officer in the violation report, that was the other thing I was going to mention, because the probation officer committed clear error and missed the fact that there's only one term, and everybody else involved in the proceeding missed it, doesn't change his intent of what he did back in January. And I fully believe that his intent, first of all, I don't think we get there. There's no ambiguity. The written judgment and the oral judgment are not in conflict. They both say a term. Second of all, even if you were trying to figure that intent out, if you looked at the whole record, I think the judge intended to impose one term of supervised release. So if this kid walked away from his halfway house and didn't go back, that he could give him more supervised release, which is what the judge did. I don't think he intended initially in January to impose 5 terms. I think this judge would have done it if that's what he meant to do. If he would have said it and he would have written it in the judgment. Also, I don't want to give the court the impression that I have waived my second. I do believe that we have an unreasonable sentence in this case, and I've presented my arguments. I think that the heart of my argument is that we have a case where the defendant walked away from the Salvation Army. He was supposed to go to the Salvation Army. He left the facility and they wouldn't let him back in. And he wasn't supposed to leave the facility, don't get me wrong, but they wouldn't let him back in because of COVID. He did try to get back in. And as a result of that, he went from a 3-week sentence to a 70-month sentence. And I do think the court is authorized to look at the reasonableness and weigh the overall facts in this case and make a determination of whether that was a substantive.
There's a long history, though, with the judge with this. I mean, not too long, but the judge exercised extreme patience with this guy over a pretty long period of time.
He did, Your Honor, and I think that's why he handed down such a harsh sentence in May. I understand that, but I think that's part of our argument that he will put too much weight on the fact that the defendant did not follow through, or he left the Salvation Army. And again, he did try to get back in. And I think if you look at other revocation cases, that this one is out of line with what defendants normally get for this conduct. Thank you.
Thank you, counsel. We have your arguments. Thank you.
Thank you.